Okay. Good afternoon. Okay, bali let us continue our discussion dun sa obligation. Okay. Now, kind of obligation according to subject matter, pwede siyang real obligation, pwede siyang personal obligation. Yung real obligation, pwedeng obligation to deliver a determinate thing, or pwedeng obligation to deliver an indeterminate or generic thing. Okay, di ba in-explain ko na before na yung distinction between determinate and generic is important in case of loss. Because if the object is determinating at yung object ay na-loss without fault ng debtor, obligation ng debtor extinguished. However, if the object is an indeterminate or generic thing, whether or not the object is lost with or without fault of the debtor, the obligation is not extinguished based on the doctrine of genus non quam perit, or generic never perishes. Now, for personal obligation, pwede siyang positive or negative. Pag positive personal obligation, obligation to do. Pag negative personal obligation, the obligation not to do. Okay, now let us discuss first yung obligation to deliver a determinate thing. Now, meron, 5 duty ang debtor to deliver a determinate thing. Number 1 is to preserve the thing pending delivery. Bali, covered yan ng Article 1163. Sabi doon, every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or stipulation requires another standard of care. Okay, second is to deliver the fruits. Under Article 1164, the creditor has the right to the fruit of the thing from the time the thing to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Okay, yung third duty ng debtor is to deliver accession accessory. Now, under Article 1166, the obligation to deliver a determinate thing shall include the delivery of both the accession accessory, even though it may not have been mentioned. And of course, number 4 is to deliver the thing itself, either actual or constructive delivery. And last, to be held liable for damages in case of breach. Okay, now makikita mo naman yan sa Article 1170. Okay, now sa Article 1170, okay, those who in the performance obligation are guilty ng fraud, negligence, delay, or in contravention ng tenor of obligation shall be liable for damages. Okay, unahin natin yung first duty ng debtor to deliver a determinate thing, to preserve the thing pending delivery. I repeat, sabi ng 1163, every person obliged to give something is also obliged to take care of it with proper diligence of a good father of family, unless the law or stipulation requires another standard of care. Kaya general rule, ang duty lang ng debtor pending delivery is mag-exercise ng diligence of a good father of a family. Now, ano bang ibig sabihin ng diligence of a good father of a family? Actually, parang same siya as average diligence. Okay? Now, meaning, kung paano ka raw mag-take care ng own property mo, dapat ganun din yung diligence na i-exercise mo dun sa object na i-deliver, sa creditor. Okay, actually, yung first duty ng debtor dito is important. Okay, because kung walang duty ang debtor, to preserve the thing pending delivery, the obligation becomes useless. Katulad niyan, ang obligation ko, mag-deliver sa'yo ng specific horse next month. Okay? Pero wala akong duty na i-preserve yung thing pending delivery. Yan ginawa ko, hindi ko pinakain yung kabayo. Okay, nung dumating na yung date of delivery, patay na yung kabayo. Okay? Kasi nga, wala kang duty to preserve. Okay? Now, the obligation becomes useless. Kaya importante yung Article 1163. Okay? Now, I repeat, pag sinabing average diligence, okay, or ordinary diligence, it means kung paano ka mag-exercise ng diligence in your own property, dapat yan din yung diligence na i-exercise mo dun sa obligation na i-delivered sa creditor. Like for instance, yung obligation ko ay mag-deliver ng specific course next month. Now, pending delivery, syempre, first I need to feed the horse. Kailangan pakainin mo siya. Okay, kung merong sakit yung kabayo, dapat ipagamot mo. Kung naiinitan siya, paypayan. Hindi naman ganun. Okay? Baka kung naiinitan, dapat ipasok mo lang sa daily. Yung tinatawag na diligence of a good father of a family. Okay, pero merong exception. Number 1, by provision of law. Okay, example number 1 is law on common carrier. Kasi yung common carrier, may reason of public policy, okay, they are bound to exercise an extraordinary diligence. Okay, pangalawa yung banking business. In fact, sabi ng Supreme Court sa case ng Jempasaw versus Court of Appeal, yung banking business daw, by reason of public policy and they show to the public that they're expert in banking industry, they are bound to exercise a high degree of diligence. Pag sinabing high degree of diligence, it must be more than ordinary diligence of a good father of family. Okay, even though yung depositor daw, nagde-deposit ng small amount or million of pesos. Dapat same diligence. And of course, another is by stipulation. Pero take note, yun sa stipulation, kailangan merong express agreement na okay, yung debtor is bound to exercise okay, another okay, standard of care. Kasi pag walang nakalagay na stipulation, then babalik lang tayo sa general rule. Okay? It means diligence of a good father of a family. Second is to deliver the fruits. By the way, meron tayong tatlong klaseng fruit under the civil code. Okay, una, yung tinatawag na natural fruits. Second, industrial fruits. And third is the civil fruit. Yung natural fruits daw are spontaneous product of the soils and the young and other products of animals. Okay? Wala tong mga human intervention. Okay? Tingnan nyo na lang yung picture. Yung industrial fruits naman, these are produced by land of any kind through cultivation or labor. Tulad ng mga palay, tatanim mo muna, kukultivate. Kailangan dito ng labor muna, baka okay bago siya ma-produce. Okay, meron siyang human intervention. Yung civil fruits naman, okay, mga rent of building, price of lease of land and other property, and the amount of perpetual or life annuities or other similar income. Okay. By the way, kasama rin dyan yung mga dividends sa shares of stock as well as interest on debt securities. Okay, now under Article 1164, the creditor has the right to the fruit of the thing from the time the things to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Yeah, you need to distinguish between a personal and a real right. Kasi ang personal right na acquired siya from the time the things to deliver it arises. Samantalang ang real right na acquired siya from the date of delivery. Ang tanong, what do you mean by from the time the things to deliver it arises? Pag ang obligation daw ay subject sa suspensive condition, edi syempre upon fulfillment of the condition. Kung yan naman ay subject sa suspensive period, edi upon arrival of the period. Kung ang obligation is arising from law, quasi-contract, delict, and quasi-delict, of course by provision of law. Okay, now before there is a question in the actual CPA board exam. Ang question, the buyer, the vendee, has the right to the fruit of the thing Nakalagay na sa choices, letter A, from the time the things to deliver it arises. Letter B, from the perfection ng contract of sale. Letter C, letter D, never mind. Okay, anong sagot? Okay, ang suggested answer dun, of course, is from the perfection ng contract of sale. Why? Kasi ang question niya is buyer or vendee. Okay, it means may reference sa law on sale. And under the law on sale, under Article 1537 of the Civil Code, the vendor is bound to deliver the things sold in a succession and accessory in the condition in which they were upon the perfection of the contract. Sabi dyan, all the fruits shall pertain to the vendee from the day on which the contract was perfected. Okay, pero kung ang question for instance is the creditor has the right to the fruit of the thing, ang isagot mo, from the time the things to deliver, it arises. Okay, kasi kung inaccurate naman kung sasabihin natin the creditor has the right to the fruit of the thing from the perfection ng contract of sale. Kasi hindi naman lahat ng obligation ay nag-arise from a contract of sale. Remember, under Article 1157 ng Civil Code, obligation arising from law, contract, quasi-contract, delict, and quasi-delict. Okay, now illustration. The debtor obligate himself to deliver to the creditor. Okay, a specific course. Okay, ang date of delivery is August 15, 2020. Now, take note that before August 15, 2020, before, the creditor has no right. Okay? Wala siyang right whatsoever. Kasi nga, okay, ma-acquired lang niya ang personal right from the time the things to deliver, it arises. Okay? Kaya hindi pwedeng mag-demand yung creditor ng specific performance sa debtor before August 15. Because the obligation is not yet due and demandable. Kasi magiging due and demandable lang siya simulang August 15, 2020. Kasi ito ay obligation subject to suspensive period. Pero pag dumating yung August 15, ma-acquired ng creditor yung tinatawag na personal right. Or sometimes, ang tawag natin dito, okay, ay jus ad rem or jus in personam. Okay? Ano bang ibig sabihin ng personal right? Personal right refers to the right of an active subject to demand performance to a definite passive subject. Kaya ibig sabihin, pagdating ng August 15, 2020, pwedeng mag-demand na ang creditor sa debtor ng tinatawag na specific performance. Pwede niyang i-compel ang debtor na i-deliver yung determinate object. Okay? Pero let us assume. Okay, what if, okay, pagdating ng August 15, 2020, hindi dineliver ng debtor kay creditor. Pagdating ng August 16, 2020, yung debtor dineliver yung determinate object sa third person. Okay? In this case, ang na-acquired ng third person, yung tinatawag na real right. Okay? Or sometimes, ang tawag ay jus in re. By the way, pag sinabing jus or whose, right yan. Okay? Pag sinabi nating right, okay, ito yung whose na to, okay, parang ganito kasi yan eh. Pag owner ka ng isang object, under the Roman law, okay, meron tayong tinatawag na attributes of ownership. Ano ba yung mga attributes of ownership natin under the Roman law? Tatalon muna ako ha. Okay? Ito yung tinatawag na jus possedendi, the jus utendi, the jus provendi, the jus abutendi, the jus disponendi, the jus vindicandi. Okay? Okay, jus kuday. Hindi kasama yan. Okay? Pag sinabi natin jus possedendi, ito yung tinatawag na right of possession. Jus utendi, the right to use. Di ba pag uten, T. Okay? Ginagamit yan. Kaya use, uten. Jus provendi is the right to the fruits. Kaya kung ita-transfer ko sa yung right to the fruits, sa iyo, use of fract. Okay? Ito namang utendi, the right to use. Okay? Tulad niyan, sa contract of comodatum, you transfer the use. The jus abutendi is the right to abuse. And the jus disponendi is the right to dispose. And the jus vindicandi is the right to vindicate. Bali, ito yung mga rights natin under the Roman law. Kaya tandaan nyo pag jus, I'm referring to right. Balik tayo dito. Okay, ang na-acquired dito ni third person nung dineliver, real right. And what do you mean by real right? Real right refers to the right over the rest. Pag sinabi natin rest, yung thing. Okay? Kaya pag nakarinig niyo yung word rest, referring to thing. Okay? I repeat, real right refers to the right over the rest at binding daw siya against the whole world without any definite passive subject. Kaya dito, ang na-acquired dito ng third person ownership. Okay? Nung dineliver. Kasi ang isang mode of acquiring ownership natin, okay, ay delivery. Okay, pero by the way, yung delivery kasi is only one mode of acquiring ownership. Meron tayong mga other modes of acquiring ownership under the Civil Code. Okay? Now, wait lang ha. Can you please get out muna the room? Then close the door. Okay? Thank you. Okay? Yeah. Yeah, you go out. Please. Okay. Close the door. Thank you. Okay, sorry. Okay. Balik tayo dito. Bali, I repeat, ang na-acquired dito ng third person, okay, real right, ownership. Okay, ulitin ko sa Civil Code, meron tayong mga mode of acquiring ownership. Isang mode of acquiring ownership is delivery. Okay? Yung mga different mode of acquiring ownership under the Civil Code, ito yung old tips. Bali, occupation, law, donation, tradition, intellectual creation, by prescription, saka succession. Okay, talon mo na ulit tayo ha, papakita ko lang. Bali, ito yung mga mode of acquiring ownership natin. All tips yan. Occupation, law, donation, tradition, intellectual creation, by prescription, saka succession. Yung tradition, isang mode of acquiring ownership lang. Okay? Okay, yan yung delivery. Kaya nga, may tinatawag tayong sa law on sale na constructive delivery, di ba? Which is traditio symbolica, traditio or traditio clavium, traditio longa mano, traditio brevi mano, traditio constitutum possessorium. At yung ibig sabihin ng tradition doon means delivery. Okay? Tulad sa law on sale, if I sell to you, for instance, an object for 10,000 pesos, okay, you already paid the price. But before delivery, who is the owner? Of course, the answer is still the vendor. Kasi hindi naman nagtatransfer ng ownership yung payment ng price. What transfer ownership is delivery, either actual or constructive. Pero I repeat, since yung tradition is only one mode of acquiring ownership, sa other mode, iba rin yung pag-transfer ng ownership. Like for instance, sa donation. Halimbawa, nag-donate ako sa iyo ng cellphone. Okay, dineliver ko na. Is ownership now transferred to the donee? The answer is no. Because in donation, what transfer ownership is the acceptance by the donee. Kasi ang basic rule sa donation is that no person shall be compelled to accept the generosity of another. Kaya hanggat walang acceptance ng donee, walang transfer of ownership. Pero by the way, paki-recall nyo na lang na ang donation, may formalities prescribed by law. Because under Article 748 ng Civil Code, di ba sabi doon, donation can either be oral or in writing. Okay, pero oral donation requires simultaneous delivery of the thing. Pero donation ng movable property where the value exceed 5,000 pesos, the donation and the acceptance must be in writing, even a private one. In Article 749, donation of immovable property, regardless of value, the donation as well as the acceptance must be in a public instrument. Otherwise, the donation is void. Now, another example, tingnan natin yung succession naman. Halimbawa si A, gumawa siya ng last will and testament, nag-dispose siya ng legacy in favor of a legatee. And the legatee already accepted. Question, is ownership now transferred to the legatee? The answer, of course, is no. Because in succession, what transfer ownership is not delivery? Okay, hindi rin acceptance, but rather death. Okay, because under Article 777 ng Civil Code, the right to succession are transmitted from the moment of death of the decedent. Without death, there is no succession. Sa prescription naman, mapapansin mo, another mode of acquiring ownership din siya. Okay, it means ma-acquire yung ownership through lapse of period. Kaya kung halimbawa, real property yan, pag nag-lapse na yung 10 years in good faith and 30 years naman in bad faith, then pwede ma-acquire yung ownership. Basta kailangan, it must be continuous, adverse, public, and it must be in the concept of the owner. Okay? Tulad nitong intellectual creation. Okay? It is created from the moment of its creation. Okay? Tingnan mo itong nakalagay sa provision sa Intellectual Property Code. Sa Republic Act 8293, Section 172. Literary and artistic works. Sabi dyan, literary and artistic works, hereafter referred to as works, are original intellectual creation, okay, in the literary and artistic domain protected from the moment of their creation. Meaning, owner ka niyan from the moment of its creation. Ito yung mga example niyan, mga book, pamphlets, articles, and other writings, periodicals and newspapers, lectures, sermons, address, dissertation, prepared for oral delivery, whether or not reduced in writing or other material forms, letters, and so on. Okay? Now, balik tayo dito sa illustration. Kaya, I repeat, dito na-acquired ni third person yung ownership, okay, upon delivery. Now, question. Can a creditor file a case against the third person for recovery ng possession and ownership? Okay, the answer of course is no. Because pag nag-file ka ng action for recovery ng possession and ownership, it presupposes na naging owner ka. Ang problema, hindi naman naging owner ang creditor. Okay, kaya ang remedy lang ng creditor ay mag-file ng action for damages against the debtor. Kasi hindi na possible dito ang action for specific performance. Sapagat yung determinate object, okay, ang ownership niya nalipat na sa third person. Okay? Okay, now let us proceed sa another illustration. Okay? The debtor bind himself to deliver to the creditor a specific verse on August 15, 2020. Okay, ang problema, itong kabayo, kung buntis pa yon kanina, pag nanganak yan ng August 15, 2020 and onward, entitled ang creditor. Pero kung nanganak ito, prior to August 15, 2020, entitled ang debtor. Because separable na yung principal, okay, dun sa accessory. Okay? Now, question. What if nanganak ito ng August 15. Siyempre, dapat ang entitled sa fruits, yung creditor. Kasi di ba, the creditor has the right to the fruit of the thing from the time the things to deliver, it arises. Okay? Eh, ang problema, pagdating ng August 16, the debtor deliver both the principal and the accessories to third person. Ang question ngayon, sinong may better right dun sa fruits? Okay, the answer of course is the third person. Why? Kasi ang na-acquired ng third person ng dineliver is a real right. Okay, ang na-acquired ng creditor noong August 15, nung pinanganak ito, is only a personal right. Kaya pwede nang i-compel yung debtor na i-deliver yung determinate object, the principal, plus the accessory. Pero ang problema, kung dineliver pa rin ng debtor sa third person ng August 16, yung principal plus accessory na acquired ng third person, yung tinatawag na real right. Kaya lumalabas ang ownership na lipat sa third person. Kaya ang recourse lang ng creditor, mag-file ng action for damages against the debtor. Okay. Now, let us proceed now sa another duty ng debtor. Okay, to deliver a determinating. Yung third duty niya is to deliver both the accession and accessory. Sabi ko nga dun sa Article 1166, sabi dyan, the obligation to give a determinating includes that of delivering all its accessions and accessories, even though they may have not been mentioned. Kaya halimbawa, I am the debtor, you are the creditor, my obligation is to deliver a specific card. Ang problema yung specific card, merong naka-install na GPS. A, merong extra tire. Okay? At kung mga anong abubot pa na naka-fix, okay, doon sa car. Okay, dapat i-deliver to ng debtor. Kasi nga, okay, para ma-exclude siya, okay, dapat merong express stipulation. Okay? Kaya, therefore, para ma-exclude yung both accession and accessory, dapat merong stipulation. Okay, ano ba yung accession? Fruits of thing daw, addition, improvement upon a thing, like house, trees on a land. Okay, accessories naman, these are things joined with the principal for embellishment, better use, or completion daw. Example nito, key of house, bracelet, of a watch. Okay. The fourth duty of the debtor to deliver the terminating is to deliver the thing itself. Pwede siyang actual or constructive delivery. Okay, pag sinabing actual delivery, di ba sabi ng Article 1497, the thing sold shall be understood as delivered when it placed in the control and possession of the vending. Kaya yung actual delivery, transfer of control and possession. Pero di ba pag sinabing constructive delivery, ito yung tinatawag na delivery by fiction of law. Okay? Example ng constructive delivery, number 1 is execution of public instrument. Bawa, nagbenta ako sa iyo ng parcel of land. Okay, nag-execute ako ng deed of sale in a public instrument that constitute delivery of the land. Okay, another is traditio symbolica or traditio clavium. Okay, symbolic delivery. Like for instance, my obligation to you is to deliver 10,000 sacks of rice. Okay, and the 10,000 sacks of rice is stored in a warehouse. If I deliver to you the key of the warehouse, that constitutes delivery of the 10,000 sacks of rice. Another is traditio brevi manu. Okay, now tinawag siyang pag sabing brevi manu, shorthand. Okay, sabi dyan, a possessor of thing not as owner become the possessor as owner. O bakit siya tinawag na brevi manu? Kasi you don't need to physically deliver the object because the other party or the vendee is already in actual physical possession. Example. A and B, they entered into a contract of lease. Okay? Lease contract ng car. Si A yung lessor, si B yung lessee. Okay, di ba sa contract of lease, yung ownership na kay A, pero yung physical possession na kay B. lessee. Okay, ang term ng lease kunwari 6 months. Ang problema, nung nag-end yung lease contract, okay, bago ibalik ni B yung car kay A, si B, gumawa siya ng letter of offer. Nabilhin yung kotse. And A accept it. And B already paid the price. Okay, ang question is that, if A required to physically deliver the car to B, no need. Kasi si B is already in actual physical possession. Kaya ang mode of delivery lang ni A kay B ay tinatawag na tradisyo breve mano. Ano naman yung tradisyo longa mano? Pag sabing longa mano means long hand. Okay? Kaya ito yung tinatawag na mere consent lang or agreement ng parties by pointing out the object. Okay? And another is traditio constitutum possessorium. A possessor of a thing as an owner retain possession no longer as owner, but in some other capacity. This is actually the opposite of traditio brevi mano. Okay, example is sale and leaseback transaction. I sell to you the object, then I will immediately lease it back. Dito, pag nilease back to siya, I am now possessing the object no longer as owner, but as a lessee. Okay, example class, I sell to you 10 cars for 500,000 each. Okay, I physically deliver to you the 9 cars, but with respect to the 1 car, I immediately lease it back. Ang question, okay, how many cars, okay, ang na-transfer ang ownership kay B? Of course, the answer is 10. Bali, 9 by actual delivery and 1 by traditio constitutum possessorium. Okay, next. Okay, punta tayo dun sa, okay, last duty ng debtor to deliver a determinate fee. Okay, to be held liable for damages in case of breach. By the way, yung non-performance kasi ng debtor sa creditor, pwede siyang, okay, may breach, meaning through the fault ng debtor, or pwedeng without fault on the part of the debtor. Kung nagkaroon ng non-performance sa part ng debtor, through his fault, ang mag-a-apply is Article 1170. Pero kung nagkaroon ng non-performance sa part ng debtor without his fault, then pwede natin i-apply yung Article 1174 ng Civil Code sa fortuitous event. Okay, by the way, if you look Article 1170, meron ditong binanggit na 4. Fraud, negligence, delay, and of course, those who in any manner contravenes the tenor thereof, meaning contravention ng tenor of obligation. Okay, unahin natin yung fraud. Okay, sometimes call it dolo. Okay, ang dolo, okay, pwede siyang dolo causante or the causal fraud, or pwede rin siyang dolo incidente or the incidental fraud. Okay, yung dolo causante, bali yan yung fraud na dinefine, okay, under the Civil Code. Okay, ang nakalagay doon is there is fraud when through insidious word or machination of one contracting party, you induce another to enter into a contract without which he would not enter it. Now, meaning, kaya nakipagkontrata yung kabilang party kasi nag-employed ka ng fraud. Kaya lumalabas, merong tinatawag na defective consent. Okay? Kaya nga doon sa 1330, whose consent is vitiated by mistake, violence, intimidation, and influence saka fraud is voidable. Kaya lumalabas ang remedy nyo, pag may dolo causante, pwede ka mag-file ng action for annulment plus damages. Kasi lumalabas, the consent is defective. In relation to 1390 of the Civil Code, okay, di ba nakalagay nun, the following contracts are voidable even there is no damage to either contracting party. Number 1, when one contracting parties are incapable to give consent, and second, whose consent are vitiated by mistake, violence, intimidation, undue influence, saka fraud. How about yung dolo incidente? Sa dolo incidente, at the time there is a meeting of the minds, there is no fraud employed. Kasi nagkaroon lang ng fraud at the time of performance. Kaya dito, okay, hindi kayo pwedeng mag-file ng action for annulment. Dapat pure damages lang. Kasi wala namang defective consent. Kasi dito nagkaroon nga ng fraud in performance lang. Okay? O kung nagkaroon man ng fraud at the time of perfection, irrelevant or immaterial siya. Okay? Now, ang fraud as to period, pwede raw siyang future fraud or pwede rin siyang past fraud. Now, yung future fraud, waiver ng future fraud, governed ng 1171. Sabi ng 1171, responsibility arising from fraud is demandable in all kind of obligation. Any waiver of an action for future fraud is void. Okay, kaya pag nagkaroon ng waiver ng future fraud, void. Now, why? Kasi contrary siya against public policy. Because you're encouraging the other party to commit fraud. Okay, example. Si A and B nag-enter ng contract. Si A, ang kanyang obligation kay B, mag-deliver ng 10 units of iPhone X, original. Pero may agreement between D, A, and B na pag si A ay nag-deliver ng fake iPhone X, A is not liable. Okay? Later on, si A nag-deliver ng fake iPhone X. Is A liable for damages? The answer is yes. Paano yung agreement nila hindi liable si A? Void yung agreement sapagkat yan ay waiver ng future fraud. Okay, kasi parang ini-encourage mo pa yung other party nga na mag-commit ng fraud. Parang sinasabi lang dito sa agreement nila, alam mo, kahit mag-deliver ako sa iyo ng fake iPhone, hindi ako liable for damages. Kaya parang sinasabi mo, sige, mag-deliver ka na ng fake. Hindi ka liable for damages. Ini-encourage mo pa yung other party na mag-commit ng fraud. That's why that is contrary to public policy. Okay. Now, how about waiver of future negligence? Okay, is that valid? Answer, kung simple negligence, valid. Pero kung future negligence, void. Kasi kung yan ay future gross negligence na, at ang gross negligence, okay, is amounting to bad faith na, then, okay, it will be considered as fraud na rin. Kaya nga sabi ng Article 1173, okay, the same rule in case of negligence which shows bad faith. Ibig sabihin, if the negligence is coupled with bad faith, then same na siya as fraud. Kaya waiver ng future negligence coupled with bad faith is also null and void. Okay, how about past fraud? Pag waiver ng past fraud, valid. Why? Okay, because kinokondon, this is just a condonation of the past fraud committed. Kasi na-commit na yung fraud eh. Kaya kung i-waive ko lang siya, pinapatawad ko lang yung past fraud na na-commit. Pero kung hindi pa na-commit yung fraud, pero wini-waive mo na siya in advance, that is contrary to public policy. Kasi nga, I repeat, you're encouraging the other party to commit fraud. Tapos naman tayo sa negligence. Okay, sometimes ito, tinatawag natin culpa. Okay, ano bang ibig sabihin ng negligence? In Article 1173, sabi dyan, the fault or negligence of the obligor consists of the omission of the diligence which is required by the nature ng obligation correspond with the circumstances ng person, time, and place. Okay? By the way, yung negligence kasi is on a case-to-case basis. Okay, nakadepende raw yan sa nature ng obligation. Okay, and correspond with circumstances ng person, time, and place. Example. Okay, driving for instance at 3 p.m. without headlight do not constitute negligence. Okay? Pero kung nagda-drive ka ng 3 a.m. in the morning without headlight, that constitutes negligence. That is circumstances of time. Okay, driving at 100 km per hour at SLEX or NLEX or sa Skyway, okay, do not constitute negligence. Pero kung nagda-drive ka ng 100 km/h, yan sa may Divisoria Market, okay, kung sa matraffic na lugar, then that constitute negligence. That is circumstances of the place. Okay? Now, smoking per se do not constitute negligence. Pero kung nag-smoke ka near Caltex or Petron or sa Shell, that constitute negligence. Circumstances of place pa rin yan. Okay? Kaya nga yung negligence is on a case-to-case basis. Okay, now, meron tayong tinatawag na culpa contractual, culpa criminal, and the culpa achilliana. Yung culpa contractual, meron kayong existing contractual obligation. Meron ng existing obligation arising from contract. But because of the fault or negligence, you commit breach. Okay? Yan yung Article 1170. Pero sa culpa criminal, wala pang existing obligation. Because the obligation arise because of the fault or negligence that constitute a criminal act. Yan yung tinatawag nating delict. Yung culpa achilliana, wala pang existing obligation. And the obligation arise because of the fault or negligence that do not constitute a criminal offense. Okay, yan yung quasi-delict. Okay? Kaya yung culpa criminal and culpa achilliana are sources of obligation under Article 1127 ng Civil Code. Pero yung culpa contractual, hindi siya source ng obligation. Okay? Kumbaga, sources for damages, basis for damages under Article 1170 of the Civil Code. Now, under the Roman law, meron ba tayong negligence dati? Under the Roman law, meron siyang classification na culpa lata, culpa levis, and culpa levissima. Yung culpa lata, grave negligence. Yung culpa levis, ordinary. At yung levissima, ito yung tinatawag nating slight negligence. Next is the delay. Okay? In Latin, mora. Okay? Tandaan nyo yung mora. Madali tandaan yan. Mora. Okay? Di ba pag delay ka na, puta mo morahin ka ng nanay mo. Okay? Kaya mora is delay. Now, i-distinguish natin yung ordinary delay from a legal delay. Kasi pag sinabing ordinary delay, nagkaroon lang ng non-performance sa part ng debtor on the date fixed by the parties. Okay, without demand, whether judicial or extrajudicial. Example lang. My obligation to you is to deliver a specific horse due today. Hindi ako nag-deliver today. Okay, ang tanong, legal delay na ba ako? The answer is no. I am just in an ordinary delay. Kasi wala ka pang demand, whether judicial or extrajudicial. Okay, kaya ang basic rule is no demand, no legal delay. At take note, pag ang creditor kasi, hindi siya nag-demand, okay, on the date fixed by the parties. Ang presumption ng batas, binibigyan lang ng creditor ang debtor ng extended period of performance. Kaya I repeat, no demand, no legal delay. Pero pag sinabing legal delay na, nagkaroon na ng non-performance sa part ng debtor on the date fixed by the parties after demand, whether judicial or extrajudicial. Okay? Ngayon, delay on the part of the debtor is called mora solvendi. Pero pag ang tanong sa problem is delay on the part of the debtor in obligation to give, then sagot niya dapat ay mora solvendi ex re. Kasi ex re means real obligation. Pero pag legal delay on the part of the debtor on obligation to do, then it should be mora solvendi ex persona. Pero take note, nagkakaroon lang ng legal delay, okay, sa personal obligation pag positive. Kasi walang legal delay once na ito ay negative, okay, personal obligation. In other words, nagkakaroon lang ng legal delay pag positive obligation. Kasi once ng negative obligation to, like obligation not to give or obligation not to do, okay, walang legal delay. Because how can you be an illegal delay if you are prohibited to perform an act? Now, delay on the part of creditor, we called it mora accipiendi. Okay, and delay on the part of both debtor and creditor is called the compensatio. Now, take a look yung compensatio mo rin. Tingnan mo yung legal effect niya. Kasi pag may compensatio mo rin, mag-o-offset ang legal delay ng both debtor and creditor. Kaya lumalabas as if, okay, wala nang legal delay sa part ng both debtor creditor. That's why if the object is a determinating, okay, at yung object ay na-lost by a fortuitous event, obligation ng debtor is extinguished. Okay? Pero tandaan nyo kung meron siyang mora solvendi at yung determinate object ay na-lost by fortuitous event, obligation is not extinguished. Kasi co-convert yan into monetary obligation for damages. Okay? Okay, illustration. The debtor bind himself to deliver to the creditor a specific horse. Ang date of delivery is December 1, 2011. Okay? Now, hindi ko lang na-adjust. It should be dapat 2020, pero by the way, okay lang yan. Ang problema, tinamaan to ng lightning ng December 3, 2011. Okay, ang tanong is the obligation ng debtor extinguished. Okay, answer. Okay, the obligation of the debtor is extinguished. Why? Because the determinate object was lost by a fortuitous event before the debtors incur legal delay. Because no demand, no legal delay. Kasi wala akong mention sa problem na nagkaroon ng demand. Okay? Now, I repeat, nung hindi nag-deliver yung debtor noong December 1, 2011, ordinary delay lang siya. Okay? Ang problema, noong December 3, 2011 nga, since yung determinate object na lost by fortuitous event, extinguished. Another illustration. The debtor bind himself to deliver to the creditor a specific horse on December 1, 2019. Yung creditor nag-demand noong December 1, 2019 but there is no delivery. Pagdating ng December 3, 2019, yung determinate object na lost by a fortuitous event. Question, is the obligation of the debtor extinguished? Okay, technically, di ba dapat yung obligation ng debtor is extinguished? Kasi kung nag-iisa lang yung object, hindi mo siya pwedeng i-replace ng another object of the same kind and quality. Pero since nagkaroon ng legal delay, then i-convert siya into monetary obligation for your damages. Yan sagot natin, no. Because even if the determinate object was lost by a fortuitous event, but after the debtors incur legal delay. Kaya in that case, i-convert siya into monetary obligation for pure damages. Another illustration. The debtor bind himself to deliver to the creditor a specific horse. Date of delivery, December 1, 2019. Okay, however, yung creditor, nag-demand siya as early as November 28, 2019. Okay? Pagdating ng December 3, 2019, yung determinate object na lost by fortuitous event. Ang tanong, is the obligation ng debtor extinguished? The answer is yes. Why? Because the determinate object was lost by a fortuitous event before the debtors incur legal delay. Okay, sabi mo, sir, di ba may demand na no November 28? But the demand is premature. Kaya lumalabas as if there is no demand, it will not put the debtor in a legal delay. Kasi para magkaroon ng mora solvendi, okay, the following requisite must be present. First, obligation is already due and demandable. Kasi kung hindi pa siya due and demandable, hindi ka pwedeng mag-demand. Okay? Pangalawa, there is a non-performance by the debtor. At pangatlo, yun nga, may demand ng creditor, whether judicial or extrajudicial, unless of course demand is not necessary to put the debtor in a legal delay. Kasi meron tayong exception eh. Merong instances na even there is no demand whether judicial or extrajudicial, it will put the debtor in a legal delay. Now, balik tayo sa general rule. Sabi ng Article 1169, those obliged to deliver or to do something incurs delay from the time the obligee judicially or extrajudicially demand from them the fulfillment of their obligation. Kaya general rule, no demand, no legal delay. Exception, law. Okay, tulad ng payment of taxes. Okay, hindi kailangan ng demand ng government to pay taxes to put the taxpayer in a legal delay. Kaya once hindi ka nagbayad ng taxes on time, then you might incur penalties. Okay, pangalawa, express stipulation. Dapat may express stipulation na even there is no demand, it will put the debtor in a legal delay. Another is time is of the essence. Meaning from the nature and circumstances ng obligation, it appears na yung designation ng time ang principal cause ng obligation. Okay, example nito is birthday party. Okay? O kaya wedding. Okay? Bawa, nag-hire ka kunwari ng clown para mag-perform sa birthday party. Okay? Specify mo yung date ng birthday party. Ang problema, pagdating nung birthday party, hindi nag-appear yung clown. Hindi nagpakita. Kaya napakalungkot ng birthday party. Okay? Liable ba yung clown for damages even there is no demand? Yes. Because time is of the essence. Meaning from the nature and circumstances ng obligation niya, it appears na yung designation of time ang principal cause ng contract. Okay. Another is demand would be useless as when the debtor can no longer perform his obligation. And another is performance of one party in case of reciprocal obligation. Okay, meron lang i-clarify dito. Okay, sa contract of sale kasi, di ba, when the vendor deliver the object, the buyer should pay the price. Ibig sabihin, kaliwaan dapat. That's why when the vendor deliver the object and the buyer failed to pay the price, then the buyer is guilty of a legal delay. Okay, pero what if ganito? Okay, I sell to you, a laptop computer. Okay, the vendor now deliver the object. Okay, dapat the buyer should pay the price. If I deliver the laptop, you fail to pay the price, automatic the buyer is guilty of a legal delay. Pero kung baguhin natin, okay, I sell to you a laptop computer for 50,000. Ang agreement natin, I will deliver to you the object today, then you will pay the price after 1 week. Now, let us assume that I deliver to you the laptop today. Okay, after a week, hindi ka nagbayad ng price. Is the buyer guilty of a legal delay? The answer is no. Why? Kasi meron siyang different date of performance. Okay? Pag merong different date of performance, it means the performance of one is not dependent upon the performance by the other. Kaya babalik ka sa general rule na no demand, no legal delay. Okay? Pero pag walang different date of performance, it means pag nag-deliver yung vendor, dapat magbayad yung buyer ng price. Kasi the performance of one is dependent upon the performance by the other. And last, yung contravention ng tenor ng obligation. Kaya ito yung tinatawag na breach nga eh. Kasi halimbawa, sumakay ka ng taxi. Okay? Eh nagkaroon ng accident, disgrasya. Duguan yung passenger. Is the common carrier liable? Yes. Why? Because, okay, this is a clear contravention ng tenor of obligation. Kasi ang primary duty ng common carrier ay i-deliver ang passenger safe sa destination. Kaya kung hindi nakarating yung passenger na safe sa destination, this is a clear breach of contract. Ang defense na lang, of course, dito ng common carrier ay nagkaroon ng fortuitous event. Okay? Now, punta tayo nun sa injury, damage, saka damages. Kasi yung iba na pagbabaliktad yung damage saka damages. Pag sinabing injury, injury is the illegal invasion of a legal right. Kaya kung meron kang existing right, in-invade ko yung existing legal right mo, injury yun. Pero pag sinabi namang damage, loss, hurt, or harm which result from the injury. Pag sinabi namang damages are recompense or compensation awarded for damage suffered. Kaya ang basic rule is this. Halimbawa, nagkaroon ka ng loss or harm. Sinampal kita. Puta, masakit ba? Oo, masakit. Kaya meron kang loss or harm. Ang problema, in-invade ko ba ang existing legal right mo? Yes. Okay, kasi wala akong karapatang saktan ka. Kaya lumalabas, may tinatawag injury kasi na-invade ang existing legal right mo. Kaya dapat i-compensate kita in the form of damages. Pero kung halimbawa, nagkaroon ka ng loss or harm, pero wala akong na-invade na existing legal right mo. Okay? Kasi nag-exercise din ako ng valid legal right ko. Therefore, okay, hindi ka entitled in the form of damages. Ang tawag natin dyan ay damnum absque injuria. Or tinatawag natin damage without legal injury. Kasi para makarecover ka ng damages, dapat may loss or harm ka at in-invade ko ang existing legal right mo, kaya dapat i-compensate kita in the form of damages. Katulad niyan, halimbawa, nagkaroon ng accident, nasaktan ka, pero this is due to fortuitous event. At walang negligence or fault on the part of the debtor. Kaya merong loss or harm dito, yung creditor, pero walang na-invade na existing legal right ng creditor, kaya hindi ka entitled, okay, in the form of damages. Because that is a clear damnum absque injuria. Okay, tingnan natin yung case ng Equitable Banking Corporation versus Calderon. Ito kasing si Calderon, binigyan to ng existing credit line ng Equitable Banking Corporation. Okay? Credit card. Okay, ang problema, okay, hindi siya nakapagbayad ng kanyang existing obligation. Kaya ang ginawa dito ng credit card company, kinat or pinutol yung kanyang credit line. Okay? Now, pero meron kasing provision regarding dun sa credit card. Na merong right yung credit card company, okay, na putulin or it automatic i-cancel nila yung existing credit line kapag hindi na-comply ng cardholder yung kanyang obligation or yung kanyang duty. Okay? Now, tingnan natin to ha. Ibigay ko sa inyo yung factual case muna. Okay, sometimes in September 1984, Calderon applied and was issued an equitable international Visa card for brevity. The said Visa card can be used for both peso and dollar transaction within and outside the Philippines. The credit limit for the peso transaction is 20,000 pesos, while in dollar transaction, Calderon is required to maintain a dollar account with a minimum of deposit of 3,000. Kaya pwede siya mag-purchase in dollar, pero dapat meron siyang deposit na minimum na 3,000. The balance of dollar account shall serve as the credit limit. In April 1986, Calderon, together with some reputable business friend and associate, went to Hong Kong for business and pleasure trips. Specifically, on April 30, 1986, Calderon, accompanied by his friend, Ed De Leon, went to Gucci, okay, department store located at the basement of the Peninsula Hotel, Hong Kong. There and then, Calderon purchased several Gucci items, t-shirt, jacket, a pair of shoes, etc. The cost of his total purchase amounted to 4,030 Hong Kong dollars or equivalent to 523 US dollars. Now, instead of paying the said items in cash, he used his Visa card number 4921640000019373 to effect payment, okay, thereof on credit. He then presented and gave his credit card to the sales lady, who promptly referred into the store cashier for verification. Shortly thereafter, the sales lady, in the presence of his friend, Ed De Leon, and other shoppers of different nationalities, informed him that his Visa card was blacklisted. Calderon sought the reconfirmation of the status of his Visa card from the sales lady, but the latter simply did not honor it and even threatened to cut it into pieces with the use of pair of scissors. Deeply embarrassed and humiliated, and in order to avoid further indignities, Calderon paid cash for Gucci goods and items that he bought. Okay, now tingnan natin itong nakalagay na provision doon sa credit card nila. May agreement kasi doon. The cardholder agreed not to exceed her approval credit limit. Otherwise, all charges incurred, including charges incurred through the use of extension cards, if any, in excess of credit limit, shall become due and demandable, and credit privilege shall be automatically suspended. Take note, automatically suspended without notice to the cardholder in accordance with Section 11. Okay. Now, syempre ang ginawa ni Calderon, nag-file to ng action for damages against Equitable Banking Corporation. Okay? Kasi sabi niya na na-humiliate siya, nag-suffered siya ng physical or mental suffering. Diba? Nag-suffered ka namang sleepless night, wounded feeling, moral shock, serious anxiety, best reputation. Okay? Now, makaka-recover ba siya ng damages dito? Okay? Sabi ng Supreme Court, okay? RTC judgment kasi, sabi ng RTC, okay, nag-award ng damages ang Regional Trial Court kay Calderon. Okay? Bayaran daw siya ng 150 as actual damages. Tapos the sum of 200,000 as by way of moral damages. So binigyan siya ng moral damages. Amount of 100,000 exemplary. Tapos the sum of 100,000 attorney's fee plus 500 per count hearing and cost of suit or litigation. Siyempre, nag-appeal dito si Equitable Banking Corporation sa Court of Appeal. Ang decision naman ng Court of Appeal, a fair bank decision. Okay? Pagdating sa moral damages and cost of suit are concerned. Pero yung ibang damages, tinanggal. Pero ni-reduce yung moral damages, okay, ng 100,000. Meaning from 200, 100,000. Itong mga to, wala. Okay, umakyat ito before the Supreme Court. Sabi ng Supreme Court, walang moral damages. Okay, kasi nga, okay, this is actually a clear damnum absque injuria. Kasi, okay, sabihin natin ganito Itong si Calderon, even though sabihin natin nagkaroon siya ng loss or harm, sabihin natin na humiliate siya. Nag-suffer siya ng loss or harm. Pero ang problema, na-invade ba ang kanyang existing legal right? Okay? The answer is no. Kasi valid exercise din to ng right, okay, ng credit card company. Okay, which is Equitable Banking Corporation. Kaya kahit meron kang loss or harm, pero since walang na-invade na existing legal right mo, hindi ka entitled in the form of damages. Kasi meron nga nakalagay na provision dun sa contract nila, sa credit card. Okay, kasi hindi na-comply dito ni Calderon yung requirement Okay? Kailangan i-maintain niya yung $3,000. Okay, di rin siya nakapagbayad ng kanyang existing obligation. Nabayaran yun later on na. Naputol na. Kaya lumalabas dito, okay, hindi siya entitled for damages kasi nga this is a clear damnum absque injuria. Okay, may loss or harm siya pero walang na-invade ng kanyang existing legal right kaya hindi siya entitled in the form of damages. Okay, sabi ng Supreme Court, para maka-recover itong si Calderon ng moral damages, okay, dapat lahat ito present. Kasi ito yung requisite natin for the award of moral damages. Una, dapat may evidence karon ng best misreputation. Meron kang physical or mental or psychological suffering sustained by the claimant. May proof ka na meron kang physical or mental suffering. Pangalawa, is culpable act or omission factually established. Okay, dapat may establish mo by fact na may culpable act or omission na nangyari. Pangatlo, proof that the wrongful act or omission of the defendant is the proximate cause of the damage sustained by the claimant. Okay? Dapat yung, okay, yung damage mo, yan, meron kang, okay, proof na yan yung proximate cause ng loss mo. Okay, and another, that the case is predicated on any of the instances expressed or envisioned by Article 2219 and 2220 of the Civil Code. Ibig sabihin, dapat kasama yan doon sa enumeration for the award for moral damages. Kasi kung hindi yan kasama doon sa mga naka-enumerate for the award for moral damages, hindi ka entitled for moral damages. Now, by the way, meron ditong tinanong sa bar exam before. Okay? Ang question class is this. Halimbawa, ito doon na sa unang illustration. Okay, na-aksidente, may pasahero. Siyempre yung passenger, tuguan, hospital. Siyempre masakit yun, di ba? Ilang araw kang hindi makatulog because of the pain. Siyempre nag-suffered ka ng physical or mental suffering. Nag-suffered ka ng sleepless night, wounded feeling, moral shock, serious anxiety. Ang question, can the passenger recovered moral damages? Huwag mo muna sagutin yan. Punta ka sa second illustration. Ito naman, hindi siya pasahero. Na hit and run lang. Siyempre, nung nabangga, tumilapon kunwari. Hospital. Okay, ilang araw kang hindi makatulog. Ang sakit din yun, punyeta. Okay, therefore, nag-suffer din siya ng physical or mental suffering. Suffered siya ng sleepless night, wounded feeling, moral shock, serious anxiety, reputation, and so on. Makaka-recovered pa ito ng moral damages. Natanong yan before sa bar. Okay, doon sa unahin natin tong unang illustration. Okay, dito, hindi ka makaka-recover ng moral damages. Kasi, ang reason dyan, hindi yan kasama doon sa enumeration, okay, for the award for moral damages. The only exception is that if there is bad faith on the part of the common carrier. O kaya, natodas itong pasahero, and therefore, yung kanyang legal heirs are entitled for moral damages. Eh ito, entitled? Yes. Bakit? Kasi kasama yan doon sa enumeration under the Civil Code. Kasi pag binasa mo yung provision sa Civil Code sa award for moral damages, ang first item doon ay physical injury arising from, okay, criminal offense. Okay? Letter number 1, criminal offense resulting in physical injury. Number 2, quasi-delict causing physical injury. Okay, ang problema, yung dito, kung pasahero ka, okay, hindi yan kasama rito. Okay? Hindi kasama sa 1 and 2 yan. Kasi breach of contract yun. Unlike dito, sa not passenger, ay pwede yung delict or quasi-delict. Physical injury arising from delict or quasi-delict. O, diba? Nakita niyo yung pinagkaiba niya? Dito, pasahero ka eh. Hindi yan kasama doon sa enumeration dito. Unless, of course, mapoprove nga na mayroong bad faith on the part of the common carrier para makarecover yung passenger ng moral damages by jurisprudence yan. Now, okay, yan yung mga kasama sa enumeration for award ng moral damages. Seduction, abduction, rape, or other act of lasciviousness, adultery, concubinage, illegal or arbitrary detention or arrest, illegal search, libel, slander, or any other form of defamation, malicious prosecution, act mentioned in Article 309, act, okay, and action referred to in Article 21, mga abuse of right, 26, 27, 28, 29, 30, 32, 34, and 35 ng Civil Code. Kaya kung hindi kasama dito, okay, ang rule is hindi ka makaka-recover ng moral damages. Okay, now, paano naman kung nagkaroon ng breach without fault on the part of the debtor? Ang mag-a-apply dyan yung Article 1174 ng Civil Code. Okay, no person shall be responsible in case of a fortuitous end. Okay? Now, kasi di ba sa Article 1174 ng Civil Code, okay, ang sabi kasi doon, except as other provided by law, or otherwise provide by stipulation, or when the obligation requires the nature of assumption of risk, no person shall be responsible for those events which cannot be foreseen or though foreseen were inevitable. Kaya ang rule nga natin is no person shall be responsible in case of a fortuitous event. Ang exception is law. Pangalawa, express stipulation. At pangatlo, nature ng obligation requires the assumption of risk. Now, under law, number one, pag may legal delay. Kasi di ba pag yung debtor is guilty na ng mora, solvendi, kahit yung determinate object ay na-lost by fortuitous event, obligation is not extinguished kasi co-convert lang yan into monetary obligation for damages. Pangalawa, ito bad faith kasi nag-promise ka to deliver the same thing to two or more person would not have the same interest. Example nito, halimbawa, nag-promise akong i-deliver kay A yung specific laptop. At the same time, pinamis ko rin i-deliver yung same specific laptop kay B. Kahit naman walang fortuitous event the debtor, I cannot deliver the same object to different person having different interest because that is physically impossible. How can I deliver the same object sa different person having different interest? Okay? Bad faith ka. Okay, pero let us modify. What if I promise to deliver a specific object kay A? At the same time, pinamis kong i-deliver yung specific object kay B. Okay, ang problema si A, agent lang ni B. Ang problema yung determinate object na lost by fortuitous event. Anong effect? Obligation ng debtor extinguished. Why? Kasi even though I promise to deliver the same object sa different person, but they have the same interest. Okay, because the agent serve only as an extension of the principle. Okay? Another is loss of generic thing. Kasi dito mag-a-apply yung doctrine of genus non quam perit or generic never perishes. Another is obligation arising from crime. Okay, di ba? Ang rule kasi doon sa Article 104 ng Revised Penal Code, ang civil liability is restitution, reparation, saka indemnification for consequential damages. Kaya kahit nawala yung determinate object, kung galing yan sa criminal offense, hindi pa rin siya extinguish. Pupunta ka sa, di ba, reparation. Okay, co-convert into monetary obligation for damages. Except lang, pag yung creditor ay guilty ng mora accipienti. And of course, next, is stipulation. Dito, kailangan may express stipulation. Na pag ang object, kahit malos ang object by fortuitous event, obligation is not extinguished. And number 3, nature ng obligation requires the assumption of risk. Okay, example nito insurance. Halimbawa, kumuha ka ng property insurance. In-insured mo yung house mo against fire. Para pag nagkaroon ng sunog, due to fortuitous event, makompensate ka ng insurance company. Ang problema, later on, nasunog yung bahay mo. Due to fortuitous event. Pero sabi ng insurance company, they are not liable because that is fortuitous event. Hindi pwede. Sapagkat yung nature ng obligation requires the assumption of risk. The otherwise, hindi na magiging liable yung insurance company. Now, diyan ka muna. Now ano ba yung requisite para maging liable ang debtor? Ano ba yung requisite para ma-exempt ang debtor by reason of a fortuitous event? Sabi ng Supreme Court, in fact, in several cases, sinasabi ng Supreme Court para ma-exempt yung debtor because of fortuitous event, the following requisite must be present. 1, the cause of the unforeseen and expected occurrence or the failure of the debtor to comply with his obligation must be independent of human will. 2, it must be impossible to foresee the event which constitute the caso fortuito, or it can be foreseen daw. It must be impossible to avoid. Number 3, the occurrence must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner. And last, the obligor daw must be free from any participation in the aggravation of the injury resulting to the creditor. Kaya hindi porke may 427, abay automatic exempted na kaagad yung debtor. Kailangan lahat ng requisite dito must be present. Okay, yung una nakalagay, the cause of the unforeseen and expected occurrence or failure of the debtor to comply with his obligation must be independent of human will. Kailangan dito independent of human will or at least ng debtor. Tulad ng typhoon. Act of God dyan, di ba? Typhoon, okay, earthquake, volcanic eruption, okay, that is independent of human will. Or at least ng debtor, like act of man. Like robbery, okay, by using force or intimidation, as well as war, okay, rebellion, okay, pwedeng mag-fall under 427. Terrorism, okay. Pangalawa, it must be impossible to foresee the event which constitute the caso fortuito. It can be foreseen, it must be impossible to avoid. Tulad ng typhoon. Ang typhoon is foreseeable, but you cannot avoid it. Okay? Now, okay, how about yung earthquake? Oh, that is, okay, unforeseeable. Okay, volcanic eruption. Okay, sabi nila, yung volcanic eruption, hindi mo alam yung exact date kung kailan sasabog, pero nagbibigay siya ng warning. Kaya lumalabas, pwede rin siya mag-fall under, lumalabas dito. Okay, something foreseeable ba? Okay, pwede nating sabihin na yes, pero hindi natin alam lang yung, alam natin sasabog, pero hindi natin alam kung exactong date lang. Okay, now, another is the occurrence must be of such as to render it impossible for the debtor to fulfill obligation in a normal manner. Halimbawa, ang obligation ko sa'yo mag-deliver ng specific horse. Okay? Ang problema, nagkaroon ng strong earthquake, intensity 10. Okay? Ang question, is the obligation ng debtor extinguished? The answer is, hindi pa. Baka mamaya pala yung kabayo, nakatayo lang dyan, buhay na buhay. Kaya ibig sabihin, kahit may 427, as long as the debtor can perform his obligation in a normal manner, obligation ng debtor is not extinguished. And last, the obligor daw must be free from any participation in the aggravation of the injury resulting to the creditor. Ang ibig sabihin lang yan, dapat yung debtor daw must be free from any contributory negligence for the additional injury suffered by creditor. Kasi baka mamaya, okay, nakipag-participate pala yung debtor, kaya lalong na-injured yung creditor, hindi ka pa rin may exempt because of a fortuitous. Okay? Now, equivalent term for fortuitous event, okay, caso fortuito, literal translation. Okay, act of God, like lightning, typhoon, volcanic eruption. Yung force majeure is really an act of man, like war or armed robbery. Saka last is yung unavoidable accident like tire blowout. Pero halimbawa, okay, brand nyo yung, halimbawa, yung gulong is luma na, pumutok yung gulong, okay, negligence. Okay, o kaya pumutok yung gulong, overloaded. That is also negligence. Kung nawala ng brake, negligence siya. Okay, kasi dapat bago ibiyahe ng common carrier yung sasakyan, okay, it must be in a good working condition. Okay? Now, by the way, dito tayo mag-stop muna sa okay, fortuitous event. I-discuss ko sa inyo next meeting, okay, yung mga cases. Some cases related to a fortuitous event. Okay? Thank you and goodbye.